the seminar at the University of Miami. Well, I think Santiago said almost everything I was going to say, so I'll take my time and some comments about what he said. One thing, everything started, I would say, 1948, even before the UN Human Rights Declaration came into effect. 6 months before, the American states, when they were creating the Organization of American States in Bogota, Colombia, they approved the Declaration on the Rights and Duties of Man. So this was a declaration that under international law had no effect. It was just on the air for 10 years after it was approved. And then a commission was created, as Santiago said, by a resolution of ministers in Chile in 1959. So there we had a declaration of human rights by the OAS member states with no legal effect at all for 10 years. And then after the commission was created and elected finally in 1960, and the members were sworn, they were asking themselves, where are we for? What is our task here? They began doing studies. They began see how the constitutions in the Americas enshrine human rights in their texts. But then some crises began to start. The Dominican Republic crisis and the Cuban Revolution crisis. So they started then visits that were not in their statute, were not in their regulations. They seated here in Miami for a month, receiving Cuban refugees information, sending the Cuban government letters, asking the Cuban government permission to visit the island, and then they went to the Dominican Republic for almost 2 years on and off. So they started to receive communications, letters, complaints. They didn't know what to do with that. The only likewise existing body was the European Commission for Human Rights. No longer existed because it was merged in the European Court already in 1999. So they began to process those petitions. They didn't have power to direct to the government any orders, any recommendations, any thoughts to implement actions, but they began receiving and processing those communications. After that, a few years later, 1963, it was recognized in their statute that they did have this power, and that is very important because the individual petition right, the right of an individual to file a petition against his own government or the government who has caused him some harm began to be developed in the inter-American system without any specific regulation in a treaty or something like that. It was just the general practice accepted by a few states, but it was the 1948 declaration that came into effect to be somehow treated as a binding instrument. And this is very important, because years before we had a treaty in the Americas. It was the practice of the Commission, it was the declaration of 1948, it was the statute of the Commission that gave effect as a leading instrument to this 1948 declaration, which is the same declaration, by the way, which is still being applied to a country like the United States of America and Canada, because they have not signed, but they have not ratified, the convention. So currently, it's very important to differentiate that the Inter-American Commission for Human Rights has jurisdiction on all member states, including U.S., Canada, and Cuba, which have not ratified the American Convention, but nevertheless, under the declaration and under the statute, are subject to its jurisdiction. The last major advancement on the status of the Commission, which is sometimes a very rare animal hanging around the member states, was in 1967 when the charter of the OAS was amended, and then the Commission itself became a principal organ of the Organization of American States. That is to say, any state which became member to the OAS will become subject to the jurisdiction of the Inter-American Commission for Human Rights. So, interesting enough, citizens of the U.S. and Canada, or inhabitants, people who happen to be here and suffer some violation on the rights enshrined in this declaration, after they exhaust domestic remedies and no redress has been awarded to their harm, no remedies have been properly in place, they can file a petition against these governments under the charter, under the declaration, and under the statute. For the rest of the countries, mainly, as Santiago said, the Latin American countries, which have ratified the convention, so the legal status is an international treaty, a binding legal instrument where you can file the individual petition for the rights violated by the state. But these human rights instruments assume that the obligation of the governments to respect and to guarantee the human rights are the obligations of the government in their jurisdiction, so that they are obliged to implement those obligations to respect, to guarantee, and to protect the rights by the different branches of government, by the policies, by the law, by the courts, by the police. So only if a violation has occurred and the violation has not been redressed or remedied by the domestic remedies is that you should go on to the international bodies to protect human rights. There are some exceptions. If reasonable time has elapsed without any decision of the court, you can also go, because these are clearly established in international law and in this instrument. But the principle is that the government themselves should be subject to these international instruments, and only afterwards you can go to the international organs to protect human rights. But then, what do we do after the Commission or the UN Committee or the African Commission renders a decision? It goes back, as Santiago was saying, to the moment of implementation again by the national level. So that is why it's important that the states comply with their international obligation on good faith, as the international law treaties establish. Good faith, and you cannot argue with your national laws, with your statutes, with your constitution, with your jurisprudence to excuse yourself as a government not to comply with your international obligations. Having said that, I think it's very important to understand how important the jurisdiction of the Inter-American Commission is, even where we speak in Miami, Florida, in the United States. Because as lawyers, after you have a case of violation of one of these rights enshrined in the Declaration, in the case of the U.S., and the state or federal courts do not redress the harm caused to an individual, you can file a petition before the Inter-American Human Rights Commission. And this is the system of cases. The system of cases has evolved very much with the coming into effect of the convention and new regulations. The cases are more and more treated with proper procedures, times, and even though the Commission receives thousands of petitions yearly, and it is not properly staffed, and it's not properly budgeted, and it tries its best, I'm sure that few flaws should be still occurring, like the one mentioned by Reverend Morris, that the case was never decided by the Commission, and is